Mr. Souza.
Sir, when a person drives, he or she is in charge of something very heavy and very powerful, able to barrel down the street at great speed. But the road is shared among many users. Road conditions dynamic. Dangerous or careless driving puts the driver's own life at risk, and pedestrians crossing the road or walking on the pavement at risk. Their actions leave a lasting impact on the victims' lives, their families, and even sometimes their own lives. In May 2008, a driver looked down briefly, veered towards the right, mounted a curb, colliding into the center median, a sign, and a couple of railings. The accident left his passenger tetraplegic and bedbound, a condition likely to be permanent. In June 2018, while en route home to Singapore from Malaysia, a family got into an accident. The parents passed away from the accident, leaving behind 2 young children. In June 2014, a 5-year-old boy had to spend more than 100 days in hospital and was permanently paralyzed on the right side of his body after a delivery driver failed to keep a proper lookout or a safe distance on the expressway. These real-life stories drive home the importance of driving responsibly. This Road Traffic Amendment Bill prevents and deters road traffic offences, as well as calibrates the punishment to achieve a more accurate form of justice in the particular situation. Allow me, sir, before I move on to other aspects of the bill, to also speak up on behalf of drivers and pedestrians. PMDs travelling fast and recklessly sometimes dart out onto the road from pavements. Such a startling appearance on road crossings causes immense danger to the drivers of vehicles and other road users and can cause death or serious injury. Pedestrians too suffer at the hands of reckless PMD users. So while the focus of this bill, which I support, is to make driving more safe, I hope the authorities and the courts can consider the serious role of reckless PMD users in causing accidents on our roads and on our pedestrian or road crossings. That should reduce the culpability of the driver of the vehicle. The other concern I have, before going into, in particular, the details of this bill, the other concern I have is about turning into a road where the traffic light is green, while at the same time a green man allows a pedestrian to cross the same road. The presence of a green light and a simultaneous green man can cause confusion, and accidents can happen. To avoid such confusion, would the rules allow for a green arrow to be coupled with a red man, or a green man to be coupled with a red arrow? This will make the road safer for drivers and pedestrians, if indeed this is possible and the traffic flow allows for such permutations. Sir, this bill prevents further road traffic offences by providing for disqualification for longer periods and for more offences in clauses 13, 14 and 17. Such offences include certain instances of dangerous driving, driving without due care and drink driving. There are also longer suspension periods under clause 8. In particular, the new section 46(2)(b) also allows a licence to be suspended after the person completes a prescribed course on safe driving. This prevents further road traffic offences not just by taking the driver off the road for a certain amount of time, but also by correcting certain driving practices. In relation to disqualification periods, is there supposed to be a difference between how the new section 65(6) and the new section 64(2)(d) operates? The words of both proposed sections are the same, but the relevant paragraphs in the explanatory statements are different. The second paragraph from clause 13 in the explanatory statement states that the disqualification periods, and I quote, serve as a guide to the court as the court retains discretion whether to order the disqualification or depart from what is in the section, unquote. On the other hand, the second paragraph in clause 14 says that, quote, under the amended Section 65, a court that convicted a person of an offence under subsection 1 must, in certain cases, order that the person be disqualified from holding or obtaining a driving licence for a period starting on the date of the person's conviction or the date of the person's release from prison, unquote. Would the Minister or the SPS kindly clarify how these proposed sections would operate? Disqualifications do not just prevent future traffic offences, they also deter potential traffic offences from happening. This second theme of the bill can also be seen in enhanced punishments and the forfeiture of vehicles. One of the crimes that has an enhanced punishment is Section 67, driving under the influence of drugs or alcohol. Every month for the first 9 months of 2018, one person lost his or her life to an accident related to drink driving. Although the number of persons arrested for drink driving decreased by 3.7% in 2018 compared to 2017, if I'm not mistaken, the number of driving accidents increased by 17.3%, with the proportion of motorcyclists increasing by 51.3%. Under Clause 17, the punishment for drink driving is roughly doubled. Instead of a minimum period of 12 months disqualification, the amended Section 67(2) provides for 2 years for a first offender and 5 years for repeat offenders. The new Section 65AA under Clause 15 also provides for forfeiture of the vehicle in certain circumstances, such as where the driver was drink driving and whose reckless driving or driving without the due care caused death or grievous hurt. Besides ensuring that there is sufficient deterrence against drink driving, we should also ensure that the victim of a drink driving accident can obtain compensation. When I asked the Minister of Transport in October last year during a parliamentary question, the reply was, I quote, "Insurance policies cannot be restricted from paying out for such liabilities incurred from drink driving," unquote. However, at least some motor insurance policies have exemption clauses that say that the insurance company, I quote, "shall not be liable in respect of 1. Any accident, loss, damage or liability caused, sustained or incurred, whilst any insured vehicle in respect of which indemnity is provided by this policy is being driven by the policyholder or by any person on the order of or with the permission of the policyholder whilst under the influence of intoxicating liquor or drugs," unquote. The victim in drink driving accidents are put in a hard position as a drink driver may not have enough money on hand to pay the victim. This would be exacerbated if the drink driver's vehicle is forfeited under Clause 15 of this bill, as the drink driver would be less able to secure a loan. I'm not saying that you shouldn't forfeit the vehicle. I'm in favour of forfeiting the vehicle. My concern is for the victim of a drink driving accident being compensated. Therefore, I'd ask the Ministry, does the Ministry have any plans to ensure that there is support for victims of drink driving accidents, whether it be ensuring that there be financial compensation or whether it be counselling to overcome any trauma from the incident? Besides controlling the situation through the introduction of deterrent, preventive and calibrated punishment regimes, what is the demographic of the drivers for the bulk of accidents and apprehensions made due to traffic offences? According to the General Insurance Association's review in 2018, the 4% dip in accident reports was largely attributable to fewer private hire cars and taxis on the road. How are road safety education and campaign efforts effectively targeting these more at-risk demographics? What are the common root reasons for accidents? When there is a change in traffic lights or roads, what is being done to lower the risk of accidents happening? Also, what plans does the Ministry have to enhance road safety to keep up with changing challenges, such as possible increase in delivery motor bicycles, cyclists and even users of e-scooters or other personal mobility devices who choose to flout the rules against riding on the roads? Another group of offences with enhanced penalties I would like to draw attention to is that of driving without a licence, or employing or permitting another to drive without a licence under suspension or under disqualification. The punishments have been raised significantly. For example, in the case of driving without a license or permitting or employing someone to drive without a license, the current Section 43 of the Road Traffic Act does not specify a penalty. According to Section 131, the penalty for offences without a specified penalty would be a fine not exceeding $1,000 and/or imprisonment not exceeding 3 months for the first offence and a fine not exceeding $2,000 and/or imprisonment not exceeding 6 months for subsequent offences. A lot of not exceedings in that sentence. But Clause 2 of the bill raises the penalty for these offences to a fine of up to $10,000 and/or imprisonment not exceeding 3 years for the first offence and a fine up to $20,000 and/or imprisonment up to 6 years for subsequent offences. What is the rationale for raising the penalties? Will the proposed enhanced punishment be overly harsh on individuals who may have unknowingly driven a vehicle without a licence? For example, those above the age of 65 who were unaware that their licence had expired, or whatever the age cap for that is. The third theme of the bill I want to speak on is calibration. This bill better calibrates the punishment meted out for the particular circumstance. This is most evident by the punishment regime in clauses 13 and 14 relating to dangerous driving and driving without due care in sections 64 and 65. The bill calibrates it according to culpability, aggravating factor of drink driving, or some other serious offence, gravity of hurt caused, and whether or not the offender is recalcitrant. Why is unauthorized speed trials and competition pegged to driving without due care or reasonable consideration under the new Section 65, 5A and B, and not reckless or dangerous driving under the new Section 64, 2C, A and B? There's a question mark after that. Yeah. Unauthorized competitions are deliberate and extremely dangerous, sometimes clocking speeds that more than triple the prescribed speed limit. Although Clause 15 provides that the vehicle may be forfeited for certain driving dangerously or without due care, they focus on drink driving and are ill-suited to address illegal racing, as racers may not be drunk when driving. Is it the case that the prosecution has to choose between possible forfeiture of the car and a higher possible sentence of reckless driving when charging for a situation involving illegal racing? Another way this bill allows punishment to be better calibrated is by providing for compounded offences to be taken into consideration for sentencing in the new Section 139AA, Clause 21 of this bill. This would give the court a clearer picture of the driver's driving practices and habits so that the various principles of sentencing can be more accurately weighed out. In closing, sir, I hope that educative aspects of prevention will also supplement these changes in the law to enhance the consequences of certain offences for deterrence and prevention. In the whole, this bill prevents and deters road traffic offences and provides for a better calibrated punishment system, and therefore I support it.